When love leads to marriage, the romantic whirlwind often overshadows practical considerations for the future. Yet, embracing the reality that life can be as unpredictable as it is beautiful, many couples find wisdom in planning ahead. Prenuptial agreements are not about mistrust or lack of faith in the relationship, rather, they are about applying foresight and care to ensure both partners are protected and clear about their financial rights and responsibilities. This sensible approach to matrimony allows couples to build their union on a foundation of transparency and mutual respect. In this article, we are highlighting our New Haven office, one of our 5 convenient locations. At McConnell Family Law Group, we understand the sensitive nature of prenuptial agreements and how they can secure your peace of mind as you take this significant step in your relationship. Our New Haven family law attorneys are dedicated to providing you with personalized and compassionate service, guiding you through the process with the utmost care and professionalism. If you're considering a prenuptial agreement, contact us today at 203-344-7762 and discover how we can assist you in safeguarding your future together. Why seek a prenuptial agreement? A prenuptial agreement, also known as a premarital or antenuptial agreement, is a legally binding contract between 2 individuals who are planning to get married. Through a prenuptial agreement, couples can enter into various agreements about how their separate and joint property, assets, and income will be handled during the marriage and in the event of a divorce or the death of a spouse. Couples seek a prenuptial agreement for a variety of reasons, including 1. They have children from prior relationships and want to safeguard their assets for their children in case of a divorce. 2. One person may have significantly more assets than the other person and may want to protect those assets in case of a subsequent divorce. 3. One person may have an interest in a business that cannot be disturbed or interrupted in case of a divorce. 4. One or both of them may have gone through a previous divorce and may wish to avoid the emotional and financial expense of litigating another divorce. 5. One or both of them may stand to inherit significant assets from parents or relatives and may want to protect the inheritance in case of a divorce. 5. In some cases, the parents or relatives may refuse to leave a family asset to an individual where the asset is not protected by a prenuptial agreement. Under the Connecticut Premarital Agreement Act, the parties to a prenuptial agreement may contract with respect to the following. 1. The rights and obligations of each of the parties in any of the property of either or both of them whenever and wherever acquired or located. 2. The right to buy, sell, use, transfer, exchange, abandon, lease, consume, expend, assign, create a security interest in, mortgage, encumber, dispose of, or otherwise manage and control property. 3. The disposition of property upon separation, marital dissolution, death, or the occurrence or non-occurrence of any other event. 4. The modification or elimination of spousal support. 5. The making of a will, trust or other arrangements to carry out the provisions of the agreement. 6. The ownership rights in and disposition of the death benefit from a life insurance policy. 7. The right of either party as a participant or participant spouse under a retirement plan, and 8. Any other matter, including their personal rights and obligations. However, the law contains 3 important exceptions. First, parties may not include in their agreement any provision in violation of public policy or of a statute imposing a criminal penalty. Second, the right to child support cannot be adversely affected. Any provision relating to the care, custody, and visitation of a child is subject to judicial review and modification. Third, the court may invalidate any provision of a prenuptial agreement that modifies or eliminates spousal support and causes one of the parties to become eligible for support under a program of public assistance. To have a Connecticut prenuptial agreement declared unenforceable, the party challenging the agreement must prove one or more of the following. 1. The agreement was not entered into voluntarily or was entered into under duress or coercion. For example, if on the way to the church, 15 minutes before the wedding ceremony, the bride was handed the prenuptial agreement for the first time and was told to sign it or the wedding was off, an argument could be made that the agreement was entered into under duress or coercion. Since the facts are rarely this clear, courts must often struggle making these determinations. 1. Before execution of the agreement, such party was not provided a fair and reasonable disclosure of the amount, character and value of property, financial obligations, and income of the other party. Each party to the prenuptial agreement has a duty to provide a full disclosure of the amount, character, and value of all individually owned property. 1. Such party was not afforded a reasonable opportunity to consult with independent counsel. In the first example, where the bride was handed an agreement 15 minutes before the wedding, an argument could certainly be made that she was not afforded a reasonable opportunity to consult with independent counsel. 1. The agreement was unconscionable when it was executed or when enforcement is sought. The classic definition of an unconscionable contract is one which no man in his senses, not under delusion, would make, on the one hand, and which no fair and honest man would accept, on the other. What to do before I do? Prenuptial agreements can offer many benefits, but it is essential for couples to ensure that these agreements are drafted properly. If you would like to create a clear, valid, and binding prenuptial agreement, it is important to speak with an experienced New Haven family law attorney. At McConnell Family Law Group, we can help you and your fiancé create an agreement that will provide for both of your futures, no matter what may happen in your marriage. To learn more about prenuptial agreements or to schedule an appointment with our office, contact us today at 203-344-7762 or by visiting www.mcconnellfamilylaw.com.